Welcome back to Criminal Procedure CRJU 201A. Today we're going to be discussing stop and frisk. Today's learning objectives include knowing the constitutional requirements for a stop and frisk, understanding when the police may rely on a tip from an informant, knowing whether drug courier profiles constitute reasonable suspicion, knowing the role of race in reasonable suspicion, understanding the restrictions during a reasonable suspicion stop on movement, duration, and investigative techniques, understanding Terry seizures and the occupants of automobiles, knowing when a police officer may conduct a frisk, and understanding a frisk for narcotics. The Fourth Amendment appears to require that searches and seizures be based on a warrant supported by probable cause. In 1968, the Supreme Court confronted the question of whether law enforcement may stop and frisk individuals based on a lesser standard of reasonable suspicion in Terry v. Ohio. Before Terry, stops, interrogations, and frisks without probable cause were common, especially during the social unrest of the 1960s, including civil rights demonstrations, Vietnam War protests, campus protests, and rising street crime. States like New York codified the authority of police to stop and search individuals suspected of criminal activity to protect life or limb. The President's Commission on Law Enforcement and Administration of Justice recommended that police be authorized to act on less than probable cause. Critics warned that abandoning the probable cause standard risked harassment of minorities, political activists, and vulnerable populations, while law enforcement argued that officers needed discretion to prevent imminent crimes. Justice William Douglas cautioned that weakening the standard could erode civil liberties. Historically, the court had insisted that reasonable searches required a warrant based on probable cause or exigent circumstances, as seen in Henry v. United States. Terry v. Ohio broke new ground by establishing a balancing test. Brief investigative stops may be justified by reasonable suspicion, a lesser standard than probable cause, because these stops are limited in scope and duration. The court also held that officers may frisk a suspect for weapons when there is reasonable belief that the person is armed and dangerous. The Terry holding clarified that the Fourth Amendment's reasonableness clause allows stop and frisk based on reasonable suspicion and balances the need for police to act swiftly against the minor intrusion on individual liberty. This chapter will review key topics in Terry stops, including the use of informants and hearsay to establish reasonable suspicion. There are prohibition on stops based solely on race, ethnicity, or religion, the permissible scope and duration of stops, the authority to direct vehicle occupants to exit during an investigative stop, frisks of outer clothing and vehicle compartments for weapons or drugs, and the general principle that individuals may be seized based on reasonable suspicion. The Supreme Court in Terry v. Ohio faced a new question: whether police could stop and frisk a person without probable cause. The court said yes, but only if the officer has reasonable suspicion. Reasonable suspicion is a lower standard than probable cause. It allows officers to act quickly to investigate potential crimes. The court balanced the officer's need to protect the public with the individual's right to privacy. Waiting for probable cause could put society at risk. Reasonable suspicion requires specific, observable facts, not just a hunch. The facts must be judged objectively. Would a reasonable person believe the officer's action was justified? Using this test, the court determined that the stop and frisk in Terry was lawful. Detective Martin McFadden had 39 years of experience with the Cleveland Police Department. He was working in plain clothes in downtown Cleveland. McFadden observed Richard Chilton and John Terry on a street corner. The men walked past a store window and returned to the corner repeatedly, at least 5 or 6 times. At one point, a third man, Carl Katz, joined them. Katz left and walked west on Euclid Avenue, and Chilton and Terry followed him. McFadden approached the 3 men and asked for their names. When the men mumbled a response, McFadden conducted a pat-down of their outer clothing. He found a revolver in Terry's pocket and a revolver in Chilton's overcoat. McFadden explained that he suspected the men were casing a job or planning a robbery. Justice Warren emphasized that the men's actions were each innocent on their own. However, taken together, the behavior warranted further investigation. Warren noted that an experienced officer would be expected to act on such patterns. The court concluded that McFadden had reasonable suspicion to justify the stop and frisk. We might ask ourselves whether the facts could change the outcome. How many times would the men have to walk past the store to justify reasonable suspicion? Did McFadden consider race, appearance, or neighborhood familiarity? Would his decision have been different if the men were well-dressed businessmen? All questions that remain unanswered. The Supreme Court in Terry v. Ohio provided guidance for determining reasonable suspicion. Each situation faced by the police is different. The facts that give rise to reasonable suspicion cannot be reduced to a fixed set of rules. Courts must determine reasonable suspicion on a case-by-case basis. Police officers must present specific and articulable facts. They must explain how these facts, along with rational inferences, suggest that a person has committed a crime or is about to commit one. This is called articulable suspicion. The facts are judged against an objective standard. Officers cannot rely on hunches, stereotypes, or generalizations. The evaluation is based on what a reasonable person would conclude. This protects individuals from discrimination and unreasonable searches or seizures. Officers' experience and expertise are considered. McFadden, for example, was a 39-year veteran of the police department. He knew that the store the men appeared to be casing had been the target of recent robberies. Reasonable suspicion may also come from informants. Reliable informants or corroborated anonymous tips may justify a stop. Courts consider the totality of the circumstances. They examine the suspect's behavior, whether the area is high crime, the time of day, the suspect's nervousness or calmness, past crime patterns, willingness to cooperate, and any observed patterns suggesting criminal activity. Reasonable suspicion relies on probabilities and not certainties. Individual factors may have innocent explanations. Taken together, the factors must form an objective and particularized basis to justify the stop. The officer must have a particularized and objective basis for suspecting the person stopped. This ensures the suspicion is directed at the individual and not a generalized group. Reasonable suspicion is less demanding than probable cause. Probable cause requires a fair probability that evidence or contraband will be found. Reasonable suspicion requires a minimal level of objective justification. The officer must articulate more than an unparticularized hunch. Despite these purported safeguards, it's often seen that Terry v. Ohio has taken a huge step back on Fourth Amendment rights, particularly targeting of African American individuals and minority races in policing. Judges have found reasonable suspicion sufficient to justify a Terry stop in a variety of factual situations. Reasonable suspicion often resembles a puzzle in which officers connect seemingly innocent acts to try to justify a Fourth Amendment search or seizure. Determining reasonable suspicion requires evaluating the totality of the circumstances. This differs from probable cause, which typically involves direct observation of a crime. The Supreme Court has recognized that articulating a precise definition of reasonable suspicion is impossible, and that it is instead a fluid concept that must be evaluated in a particular context. Several factors in combination have been found to constitute reasonable suspicion. These include acts indicating criminal activity, such as casing a store or exchanging money on the street. Time of day can be relevant if criminal activity is more likely at certain hours. Location matters, especially high crime areas or areas associated with specific criminal conduct. Knowledge of an individual's prior criminal record may also contribute. Evasion or fleeing from police supports reasonable suspicion. Non-cooperation or nervous behavior can also be relevant. Finally, an officer's experience and expertise helps interpret these factors. Courts have applied these factors in many cases. In United States v. Foster, officers found reasonable suspicion when a suspect smelled strongly of PCP, appeared nervous, was in a known drug trafficking area, and an officer had previously made 85 PCP-related arrests in that complex. In State v. DeVale, officers stopped a nervous driver wearing a heavy coat with a hole in the lining, which could conceal drugs or weapons. A frisk revealed narcotics and a weapon. In United States v. Glover, officers stopped Paul Glover near a service station in a high-crime area at 4:40 a.m. Observing his suspicious movements and attempts to conceal himself, a frisk revealed a firearm. In United States v. Quintana Garcia, a Border Patrol agent stopped a vehicle exhibiting evasive driving in an area favored by smugglers, combined with tinted windows, a Mexican license plate, and a prior smuggling pattern. Courts sometimes differ on whether certain facts establish reasonable suspicion. In Schneider v. State in Arkansas, a license plate color discrepancy alone justified a stop. In contrast, in the Seventh Circuit, the United States v. Uribe found that the color discrepancies alone do not suffice. In United States v. Davis, the court overturned a conviction finding that presence in a high-crime neighborhood, proximity to a juice joint, refusal to stop, and prior record were insufficient to establish reasonable suspicion. Terry provides legal support for detentions based on reasonable suspicion rather than probable cause. The court's reasoning balances the need for law enforcement to investigate criminal activity with the protection of individual liberties. Some critics argue that Terry grants police far too much discretion, resulting in the detention of many innocent individuals. Others argue that the inconvenience to a small number of individuals is minimal and that officers should have even broader authority. Subsequent cases, such as Illinois v. Wardlow, explore specific issues like whether unprovoked flight constitutes reasonable suspicion. Courts analyze these facts carefully, considering context and all surrounding circumstances. Issues such as race may arise in dissenting opinions, raising questions about the relevance of race in the reasonable suspicion analysis. Next, we'll discuss the case of Terry v. Ohio 392 U.S. 1, 1968. In this case, Richard Terry and Richard Chilton were observed by plainclothes detective Martin McFadden on a downtown Cleveland street. The men repeatedly walked past a store window, pausing each time and conferring with each other, while a third man briefly joined them and then departed. McFadden, a 39-year veteran of the police, suspected that they were casing the store for a robbery. Believing they might be armed, he approached the men, identified himself as a police officer, and asked for their names. When they mumbled a response, McFadden patted down their outer clothing and discovered firearms on both Terry and Chilton. He seized the weapons and arrested the men. The central question was whether McFadden's stop and frisk violated Terry's Fourth Amendment rights. Specifically, the court examined whether an officer can briefly detain and frisk a person based on reasonable suspicion, even without probable cause for arrest. The case also raised broader concerns about the balance between effective law enforcement and individual liberty. The court emphasized that any police intrusion on a person is governed by the Fourth Amendment. Even brief stops and limited searches constitute seizures and searches. The Fourth Amendment protects against unreasonable invasions, not just full arrests. The court applied a balancing test. On one hand, officers need flexibility to respond quickly to potentially dangerous situations and investigate criminal activity. On the other hand, individuals have the right to personal security and freedom from harassment. The court concluded that McFadden's actions were reasonable. He had observed a pattern of conduct suggesting a possible robbery. He had reason to believe the men might be armed, and he limited the search to what was necessary to discover potential weapons. The court stressed that officers do not need absolute certainty that a person is armed. What matters is whether a reasonably prudent officer, in light of experience and the circumstances, would believe that the person posed a danger. The frisk must be narrowly tailored to ensure officer safety while minimizing intrusion on personal liberty. The court held that the weapons seized from Terry were admissible. A police officer may conduct a limited search of the outer clothing of a person for weapons when unusual conduct raises reasonable suspicion of criminal activity and the officer reasonably fears for his safety. The frisk must be limited to what is necessary to discover weapons and is justified even without probable cause for arrest. In his dissent, Justice Douglas argued that any seizure of a person should require probable cause. He warned that allowing stops and frisks based on less than probable cause erodes constitutional protections and gives the police excessive discretion. Next, we'll look at Illinois v. Wardlow, 528 U.S. 119, 2000. On September 9, 1995, officers Nolan and Harvey, part of a 4-car caravan, patrolled a Chicago neighborhood known for heavy narcotics activity. While passing 4035 West Van Buren, Officer Nolan observed William Wardlow standing near a building holding an opaque bag. Upon noticing the officers, Wardlow fled. The officers pursued and stopped him a short distance away. Officer Nolan immediately conducted a protective frisk, feeling a heavy object in the bag that turned out to be a .38 caliber handgun. Wardlow was arrested for unlawful possession of a firearm by a felon. Officer Nolan testified that he expected to find an enormous amount of people, including drug customers or lookouts, and the court noted that it was in this context that Officer Nolan decided to investigate Wardlow after observing him flee. This observation, however, has been criticized for giving insufficient weight to the reasonable suspicion analysis, in light of the absence of testimony that anyone else was actually nearby when Wardlow ran. This context arguably weighs against finding reasonable suspicion. The court determined whether or not Wardlow's unprovoked flight from the police in a high-crime area provided sufficient reasonable suspicion to justify a stop. The court emphasized that mere presence in a high-crime area is not enough to justify a stop. However, context does matter, and Wardlow's unprovoked flight was considered a relevant factor along with the location to justify a brief investigative stop. The court acknowledged that flight can have innocent explanations. Many factors, such as fear of police or embarrassment, may lead to unprovoked flight, especially in high-crime areas. Thus, even in a high-crime neighborhood, unprovoked flight alone does not invariably create reasonable suspicion. The court also noted that Terry stops are intended to allow minimal intrusion for investigative purposes. The stop and frisk must be limited in scope and purpose, consistent with Officer Nolan's protective search for weapons. The Supreme Court held that Wardlow's flight, in combination with the high crime context, gave officers reasonable suspicion to justify the stop. The Illinois Supreme Court's decision to suppress the gun was then reversed. In a combination concurring and dissenting opinion, Justice Stevens, joined by Souter, Ginsburg, and Breyer, emphasized that innocent individuals sometimes flee for reasons unrelated to crime, such as fear of police or embarrassment. They argued that even the observation that Wardlow might have expected other people nearby was in a high-crime area is insufficient to justify a stop. The totality of circumstances must guide the inquiry, and the court should avoid categorical rules about flight as automatically suspicious. In Kansas v. Glover, 2020, Deputy Mark Mayer observed a pickup truck with Kansas license plate 295ATJ and ran a records check. The vehicle was registered to Charles Glover, Jr., whose license had been revoked. Based on this information, Deputy Mayer inferred that Glover was likely driving the vehicle and conducted a traffic stop. During the stop, Glover was arrested for driving as a habitual violator. The key question before the court was whether this inference, linking a revoked license to the likely driver, constituted reasonable suspicion under the Fourth Amendment. Justice Thomas, writing for the majority, emphasized that reasonable suspicion depends on probability rather than certainty, and considers the totality of the circumstances. The fact that the registered owner may not always be driving did not prevent a reasonable inference that he was the driver in this case. Mayer had no information suggesting someone else was behind the wheel, so the stop was considered reasonable. Justice Thomas noted that officers may rely on common sense inferences from everyday life, and they are not required to ignore reasonable conclusions drawn from ordinary experience. The court also cited empirical evidence from Kansas showing that a high percentage of drivers with revoked licenses continued to drive, and that these drivers were disproportionately involved in fatal crashes. This evidence, while not dispositive, supported the inference that Glover would likely be driving. Justice Kagan, concurring, highlighted that Glover's license had been revoked for serious or repeated offenses, demonstrating a history of disregarding driving restrictions. These facts further supported the reasonableness of the stop. Justice Sotomayor, dissenting, argued that reasonable suspicion must be grounded in the conduct of a particular individual rather than statistical probabilities. She cautioned against using generalized assumptions and common sense inferences, which may not reflect an officer's training or experience, and stressed that the Kansas data might not apply in jurisdictions with different licensing practices. Ultimately, the court held that Deputy Mayer had reasonable suspicion to stop Glover. The decision illustrates that reasonable suspicion can rest on inferences from circumstantial facts and does not require direct observation of wrongdoing, or certainly about the suspect's identity. It also highlights the tension in Fourth Amendment jurisprudence between granting police officers discretion to act on reasonable inferences and protecting individual liberties. Reasonable suspicion may be based on an officer's own observations or on information provided by others, including victims, eyewitnesses, informants, or police bulletins, although such information is technically hearsay. Courts recognize that while first-hand observation is often more reliable, police frequently must act on information supplied by third parties. In Adams v. Williams, the Supreme Court held that an officer may rely on a tip from a known informant when the tip contains sufficient indicia of reliability, such as prior accuracy, personal contact with the officer, and immediate verifiability. The court emphasized that reasonable suspicion requires less reliability and less information than probable cause, and that a tip insufficient to justify an arrest may still justify a brief investigative stop. The court distinguished tips from known informants from anonymous tips, which generally require additional scrutiny. In Alabama v. White, the court held that an anonymous tip may establish reasonable suspicion when police independently corroborate significant details of the tip, particularly predictions about the suspect's future behavior that suggest inside knowledge. Although the case was close, the court concluded that corroboration of these predictive details supplied sufficient reliability under the totality of the circumstances. The Supreme Court revisited anonymous tips in Navarrete v. California, holding that an anonymous 911 call may support reasonable suspicion when it bears strong indicia of reliability. The court relied on the caller's claimed eyewitness knowledge, the contemporaneous nature of the report, and the safeguards built into the 911 system. The court also emphasized that tips describing an ongoing and dangerous situation, such as suspected drunk driving, warrant greater weight. Across these cases, the court has made clear that reasonable suspicion is a practical, common-sense standard based on probabilities rather than certainty. Judges evaluate informant tips by considering reliability, the basis of the informant's knowledge, whether the information was reported contemporaneously, whether police corroborated key details, and whether the suspected conduct poses an ongoing danger. Ultimately, courts assess these factors together under the totality of the circumstances. Law enforcement officers sometimes rely on behavioral profiles to help identify possible criminal activity, including drug courier profiles developed from patterns observed in prior arrests. These profiles compare an individual's conduct to a collection of behaviors thought to be associated with criminal activity, but a match to a profile alone does not automatically establish reasonable suspicion. Courts have consistently cautioned that many profile characteristics are shared by large numbers of innocent people, and judges therefore focus on whether the officer can point to specific conduct by the particular suspect that, taken together, reasonably suggest criminal activity. The Supreme Court has avoided endorsing profiles as independent proof and instead evaluates whether the totality of the circumstances amounts to reasonable suspicion. In Reed v. Georgia, the court rejected a stop based largely on profile factors that described a broad category of innocent travelers, concluding that the officer relied more on a generalized hunch than an individualized suspicion. By contrast, In Florida v. Royer, the court found reasonable suspicion where officers went beyond the profile and discovered that the suspect was traveling under an assumed name, a fact that meaningfully narrowed suspicion to the individual detained. These cases illustrate that reasonable suspicion requires more than fitting a profile. It must rely on observable, particularized conduct that distinguishes the suspect from the general public. Innocent behavior may contribute to reasonable suspicion when combined with other factors, but characteristics common to many people cannot, by themselves, justify a seizure. Ultimately, courts treat profiles as investigative tools rather than legal shortcuts and insist that reasonable suspicion remain grounded in the suspect's own actions under the totality of the circumstances. Let's briefly review the Marconi drug profile. The primary characteristics are arriving from or departing to an identified source city, carrying little to no luggage, having an unusual itinerary such as a rapid turnaround time for a very lengthy airplane trip, using an alias, carrying an unusually large amount of currency, purchasing airline tickets with small denominations of currency, and displaying unusual nervousness. Secondary characteristics include almost exclusive use of public transportation, particularly cabs in departing from the airport, immediately making a telephone call after deplaning, leaving a false or fictitious callback telephone number with the airline, and excessively frequent travel to source or distribution cities. Claims of racial profiling arise when police stops are based on race, ethnicity, gender, or similar characteristics rather than on conduct, a practice that conflicts with constitutional guarantees of equal protection. As a general rule, race alone may never justify a Terry stop, and an officer may not detain someone simply because of who they are rather than what they do. Courts have repeatedly held that stops based solely on race or on the belief that a person does not belong in a particular neighborhood are unconstitutional. Race may, however, be considered when it is part of a specific suspect description and combined with other individualized facts that reasonably connect the person to a particular crime. In this context, race can function as one identifying characteristic among many, such as proximity to the crime scene, matching clothing, suspicious behavior, or travel along a likely escape route. Similarly, race may appear as one factor within a broader profile, but it cannot substitute for concrete observable conduct suggesting criminal activity. Cases addressing racial considerations in reasonable suspicion emphasize that the Constitution requires individualized suspicion grounded in behavior and context, not generalized assumptions or demographic characteristics. Ultimately, a Terry stop must rest on the totality of the circumstances, and reliance on race is constitutionally permissible only when it is tied to a specific description and supported by additional objective factors. United States v. Weaver is a 1992 Eighth Circuit case involving a Fourth Amendment challenge to the detention of luggage at an airport. Arthur Weaver appealed his conviction for possession of cocaine with intent to distribute, arguing that law enforcement officers lacked reasonable, articulable suspicion to detain his bags. The issue on appeal was whether the district court erred in denying his motion to suppress. In the early morning of March 8, 1989, DEA agent Carl Hicks and two local detectives were at Kansas City International Airport awaiting a direct flight from Los Angeles. As Weaver exited the plane, Hicks observed that he was carrying two bags and walking rapidly toward the taxi stand. Hicks testified that Weaver's arrival from Los Angeles, his manner of dress, and his rapid movement were consistent with characteristics of narcotics couriers based on his experience. The officers approached Weaver, displayed identification, and asked if he would answer questions. Weaver agreed. He stated that he had been in Los Angeles looking for his sister. When asked for his airline ticket, he said he had left it on the plane. When asked for identification, he said he did not have any, but provided his name and address. The officers testified that Weaver appeared nervous, noting shaking hands, rapid speech, and unsteady movement. Hicks identified himself as a DEA agent looking for drugs and asked to search Weaver's bags. Weaver initially consented, but then withdrew consent and stated that a search would require a warrant. Weaver picked up his bags and attempted to leave to catch a taxi. At that point, Hicks decided to detain the bags and seek a search warrant. Hicks informed Weaver that the bags would be detained and that Weaver was free to remove any items that he needed. Weaver resisted the detention of the bags and ultimately entered a taxi with them. When Hicks attempted to remove one bag, Weaver struck Hicks's hand and Weaver was arrested. A pat-down search revealed crack cocaine, a smoking pipe, and currency. A later search of the bags pursuant to a warrant uncovered more than 6 pounds of crack cocaine. Weaver moved to suppress the evidence, but the district court denied the motion. The Eighth Circuit held that the initial encounter was consensual and that a seizure occurred when Hicks decided to detain the bags. The court concluded that based on the totality of the circumstances known to Hicks at that time, the officers had reasonable articulable suspicion to detain the bags and therefore affirmed the denial of the motion to suppress. Chief Judge Arnold dissented, stating that the facts relied upon by the officers, particularly subjective assessments of nervousness and the consideration of race, did not adequately support reasonable suspicion and raised concerns about the scope of the Fourth Amendment protection in the airport stop. In Arizona v. United States, decided in 2012, the Supreme Court considered whether provisions of Arizona Senate Bill 1070 were preempted by federal immigration law. The court held that 3 of the 4 challenged sections were preempted by the federal government's constitutional authority over immigration and by existing federal statutes. The court did not invalidate Section 2B at that time. Section 2B required state and local law enforcement officers during a lawful stop, detention, or arrest to make reasonable efforts to determine an individual's immigration status by contacting the federal government when reasonable suspicion existed that the person is an alien unlawfully present in the United States. The individual's immigration status must be determined before their release, and the accepted method of verification is contacting Federal Immigration and Customs Enforcement. The court declined to rule on the constitutionality of Section 2B because the provision had not yet gone into effect, and therefore it was too soon to consider the issue. The court could not determine how it would be enforced in practice, and therefore declined the challenge. The majority expressed concern that detaining individuals solely to verify immigration status could unreasonably prolong detention and interfere with the federal government's administration of immigration policy. The court noted that state officers might detain individuals whom the federal government had chosen not to remove, including students or other non-citizens with deferred action. The court stated that constitutional problems could be avoided if immigration status checks were conducted during the course of an otherwise lawful detention, or after an individual had been released. The court emphasized, however, that its decision did not foreclose future constitutional challenges to Section 2B, including claims that the provision is enforced in a manner that results in racial profiling, particularly against Hispanic individuals. A Terry stop and frisk is a limited intrusion designed to investigate suspected criminal activity. Because a Terry stop serves a narrow investigative purpose and involves a limited restraint on liberty, police officers are required to meet the lower standard of reasonable suspicion rather than probable cause. The scope and duration of a Terry stop must be limited to what is reasonably necessary to carry out its purpose. As the Supreme Court stated in Florida v. Royer, an investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. Courts generally evaluate the scope and duration of a Terry stop by examining 3 factors: movement of the suspect, length of detention, and intrusiveness of police conduct. With respect to movement, a Terry stop permits only modest relocation for reasons of safety or security. Involuntary transportation of a suspect to a police-dominated location, such as a police station, generally exceeds the bounds of a Terry stop. In Florida v. Royer, the Supreme Court held that detectives violated the Fourth Amendment by removing Royer from an airport concourse to a private office to obtain consent to search his luggage. Similarly, in Dunaway v. New York and Kopp v. Texas, the court held that transporting suspects to police headquarters for questioning constituted the functional equivalent of an arrest and therefore required probable cause. The length of a Terry stop must also be limited. The Supreme Court has declined to impose a strict time limit and instead evaluates whether the police acted diligently, and without unnecessary delay. In United States v. Sharp, the court upheld a detention lasting approximately 20 minutes, emphasizing that officers pursued the investigation in a reasonable manner and that the suspect's actions contributed to the delay. By contrast, in United States v. Place, the court held that a 90-minute detention of luggage at an airport was unreasonable, where police failed to act diligently. In United States v. Montoya de Hernandez, however, the court upheld a much longer detention at the border, concluding that its length resulted from the suspect's chosen method of smuggling and was reasonable under the circumstances. Courts also examine the intrusiveness of the investigative techniques used during a Terry stop. Police are expected to use the least intrusive means reasonably available to confirm or dispel their suspicions. While force, handcuffing, or placement in a patrol car is generally associated with arrest, courts have approved such measures during Terry stops when officers reasonably believe they are necessary for safety. Courts assess factors such as the number of officers and suspects, the nature of the suspected crime, the potential presence of weapons, threatening behavior, and whether less intrusive alternatives were available. Applying these principles, courts have upheld Terry stops involving drawn weapons, handcuffing, and temporary detention in squad cars where officers reasonably believed that the suspects were armed or dangerous, as in State v. Munson and Gallegos v. City of Los Angeles. In contrast, courts have found Terry stops unlawful where police transported suspects to another location, subjected them to prolonged detention, or employed restraints and interrogation resembling a custodial arrest, as in United States v. Lopez Arias, Park v. Shiflett, and United States v. Codd. Overall, the justification for the stop defines its permissible scope and duration. When police actions exceed what is reasonably necessary to investigate based on reasonable suspicion, the stop may be deemed the functional equivalent of an arrest and require probable cause. Hybel v. 6th Judicial District Court of Nevada is a 2004 Supreme Court case addressing whether a state may require a person to identify himself during a lawful Terry stop. Larry Hybel was arrested and convicted under Nevada law after he repeatedly refused to identify himself during an investigative stop. He challenged his conviction under the Fourth and Fifth Amendments. The case arose after a sheriff's deputy responded to a report of a possible assault involving a man and a woman in a truck parked on a rural road in Nevada. When the deputy arrived, he observed a man standing outside the truck and a woman seated inside, along with skid marks suggesting the vehicle had stopped suddenly. The deputy approached the man, explaining that he was investigating a reported fight, and observed that the man appeared intoxicated. The deputy asked the man for identification. The man refused multiple times and became increasingly agitated. The deputy explained that he needed to know who the man was and what he was doing there. After repeated refusals and a warning that refusal would result in arrest, the deputy arrested the man, who was later identified as Larry Hybel. Hybel was charged and convicted under a Nevada statute requiring a person lawfully detained under reasonable suspicion to identify himself. The Nevada courts affirmed the conviction and the Supreme Court granted review. The Supreme Court held that requiring a suspect to disclose his name during a valid Terry stop does not violate the Fourth Amendment. The court explained that questions about identity are a routine and accepted part of investigative stops, and that obtaining a suspect's name serves legitimate government interests, including officer safety and effective investigation. The court emphasized that the statute did not alter the duration or scope of the stop and applied only when the stop itself was supported by reasonable suspicion. The court also rejected Hybel's Fifth Amendment claim, holding that the privilege against self-incrimination applies only to compelled testimony that is incriminating. Hybel did not demonstrate that providing his name would have posed a real and appreciable risk of self-incrimination, and the court noted that disclosure of one's name is generally not incriminating, except in unusual circumstances. Justice Breyer dissented, joined by Justices Souter and Ginsburg, expressing concern that requiring identification during a Terry stop blurs constitutional boundaries and raises questions about how officers and suspects can determine which compelled answers may be incriminating in particular circumstances. Davis v. Mississippi involved the conviction of John Davis for rape. The victim described her assailant as an African American youth. Fingerprints and palm prints at the crime scene were the only other evidence. The Meridian, Mississippi police detained at least 24 young African Americans at police headquarters for brief questioning and fingerprinting, then released them without charge. 40 to 50 other youths were questioned at school, on the street, or at police headquarters. Davis, who was 14 and occasionally worked in the victim's yard, was detained and taken to police headquarters for fingerprinting and routine questioning on December 3, 1965. Over the next 4 days, he was interrogated in a car, at his home, or at police headquarters. On December 12th, he was driven 90 miles to Jackson, Mississippi, and confined overnight. He took a lie detector test and confessed. On December 14th, Davis was fingerprinted a second time. His fingerprints, along with 23 others, were sent to the FBI, which reported that Davis's prints matched those from the crime scene. The Supreme Court held that Davis's initial detention violated the Fourth Amendment because it exceeded the temporary seizure authorized by Terry v. Ohio. The court stated that Davis had been subjected to involuntary detention and the associated harassment and humiliation without probable cause. The court acknowledged, however, that fingerprinting might be permissible under the Fourth Amendment in narrowly defined circumstances, even without probable cause. In Hayes v. Florida, Joe Hayes was suspected of burglary rapes in Punta Gorda, Florida. He was detained and taken to the station for fingerprinting. His fingerprints matched those at the crime scene, and he was arrested. The Supreme Court held that Hayes' detention for fingerprinting violated the Fourth Amendment because it was involuntary and not supported by probable cause, or a judicial warrant. The court emphasized that forcibly removing a person from home or other location for fingerprinting, even briefly, crosses the constitutional line. At the same time, the court recognized that brief field detentions for fingerprinting could be permissible if supported by reasonable suspicion, a reasonable belief that fingerprinting will confirm or eliminate the suspect's connection to a crime, and if carried out promptly. The court noted that judicial authorization might allow detention on less than probable cause for fingerprinting in some circumstances. Following Hayes, several states, including Arizona, Idaho, Indiana, Iowa, Nebraska, and Utah, enacted statutes permitting limited detention of suspects for fingerprinting and identification when a judge finds probable cause that a crime was committed and reasonable grounds to believe a specific suspect committed it, as in People v. Madsen in Colorado. Your textbook asks the question, may police officers require drivers or passengers to exit a vehicle during a traffic stop? On the one hand, this could limit individual liberty without evidence of danger, but on the other hand, officers face safety risks if motorists or passengers are armed. In Pennsylvania v. Mims, the Supreme Court held that the government's interest in officer safety outweighed the minor intrusion on the driver, and officers may require the driver to exit the car. In Maryland v. Wilson, the court extended this reasoning to passengers, allowing officers to order passengers out of a vehicle. The dissent in Wilson argued that passengers should only be removed if there is a specific belief that they pose a threat, noting that automatic removal could unnecessarily burden innocent individuals. In Arizona v. Johnson, officers stopped a car for a suspended registration. One passenger, Lemon Johnson, displayed gang affiliation and admitted a prior conviction. Officer Treviso asked Johnson to exit the car, frisked him, and discovered a handgun. The Supreme Court held that both drivers and passengers are effectively seized during a traffic stop, and officers may investigate criminal activity unrelated to the stop as long as it does not prolong the stop. Officers may frisk a driver or passenger if there are reasonable grounds to believe the person is armed and dangerous. Some state courts have imposed greater restrictions under state constitutions. In Massachusetts, the Supreme Judicial Court held in Commonwealth v. Gonsalves that officers must have a reasonable belief that their safety or the safety of others is at risk before ordering a driver out of a vehicle. Later, in Commonwealth v. Bostick, the court clarified that reasonable suspicion of criminal activity also justifies removal. In Vermont, the Supreme Court in State v. Sprague considered whether the Vermont Constitution prohibits officers from directing passengers to exit a vehicle absent reasonable suspicion. These state decisions contrast with the broader authority recognized by the U.S. Supreme Court in Mims and Wilson, But it's important to remember that the states can afford their citizens greater rights, but not less rights than the federal government. The Supreme Court in Terry v. Ohio recognized that law enforcement officers face significant risks from armed criminals, often at close range. To protect themselves and others, officers may conduct a limited frisk of a person's outer clothing if they reasonably believe the person is armed and dangerous. The frisk is carefully limited. It is meant only to discover weapons such as guns, knives, or clubs. Officers do not need to be certain that the suspect is armed. The standard is whether a reasonable officer would fear for safety under the circumstances. This is an objective test, not based on the officer's personal hunch. The scope is narrow. Officers may feel inside clothing for a weapon if they sense an object that could be a weapon. Containers may be opened only if there is a reasonable belief they hold a weapon. A frisk does not automatically follow from a stop. Suspects may dispel the officer's concern by cooperating and appearing non-threatening. Courts have upheld frisks based on factors such as a bulge in a pocket, suspicious movements, knowledge of prior violent activity, the type of crime, location in a high crime area, or being with someone arrested for a serious offense. Some courts have allowed automatic frisks in suspected drug cases, linking drugs, gangs, and weapons. Terry frisks must be limited to protecting the officer. In Cybron v. New York, the court held that talking to known drug users did not justify a frisk, and reaching directly into a pocket to seize drugs exceeded Terry's limits. Conversely, in Adams v. Williams, an officer frisked a narcotics suspect based on an informant's tip and immediately removed a pistol from his waist. The court upheld the frisk as a reasonable, limited intrusion to ensure officer safety. Terry searches can be conducted on passengers in automobiles. Remember Arizona v. Johnson, where police officers stopped a car as part of a gang investigation, and Officer Treviso suspected that passenger Lemon Montrea Johnson was armed. So, he was directed to exit the vehicle and was frisked. That's when a firearm was discovered. The Supreme Court held that officer safety outweighed the minor intrusion on Johnson's privacy, and that a passenger, like a driver, could pose a threat during a stop. Officers are not required to let a potentially dangerous person leave before ensuring the scene is safe. But what about the automobile itself? In Michigan v. Long, the court extended Terry frisks to the passenger compartment of a car. Officers stopped a car that had swerved off the road and saw David Long near the vehicle. Believing him to be potentially dangerous, officers searched the areas of the car where a weapon could be hidden, discovering a knife and marijuana. The court ruled that if an officer reasonably fears a suspect might gain access to a weapon in the car, a limited search of areas within reach is justified. That meant the passenger compartment was reasonable. Further, it also extended it to anywhere a suspect could reach. This could be under the seat or in the middle compartment. In Maryland v. Bew, the court upheld a protective sweep of a home during an arrest when officers had reasonable suspicion that a dangerous co-conspirator might be hiding there. Like Terry searches of vehicles, protective sweeps are limited in scope to ensure officer safety. In short, Terry allows limited searches of passengers, vehicles, and yes, even homes, when officers reasonably believe a suspect could access a weapon and pose a threat. What about Terry and illegal narcotics? In Minnesota v. Dickerson, the Supreme Court allowed police officers conducting a lawful frisk for weapons to seize illegal narcotics if the officer immediately recognizes the object as contraband. This is called the plain feel doctrine, which is similar to the plain view rule. Just as officers can seize visible contraband during a lawful search, they can seize contraband they feel during a lawful frisk. The key requirement is that the officer must have immediate probable cause to believe the object is illegal. They cannot manipulate or further search the object to determine its nature. This limits the scope of the frisk to ensure it remains consistent with Terry's purpose of officer safety. However, I'll ask you to consider this. At what point do we believe the officer when he touches an object and immediately recognizes it? If he pats somebody down and feels the outside of an object, how does he know that that object contains drugs? How does he know that object is drugs? If he pulls something out of someone's pocket and it's not what he thinks it is, and it's not an illegal substance, well, then that person may not be arrested, and therefore their rights aren't technically going to be brought into dispute in a court of law. Do we give officers too much leeway with the plain field doctrine? What we've discussed so far is the ideal, what a Terry stop should look like if applied correctly. However, in reality, it's far more often the case that it's abused. In New York City, Mayors Rudy Giuliani and Michael Bloomberg implemented aggressive stop and frisk policies to reduce crime and increase public safety, which they argued helped restore confidence in the city. Critics, however, challenged the practice for being applied disproportionately against African American and Hispanic individuals and for often lacking sufficient suspicion. This issue was central in Floyd v. New York City, in which the court examined stop and frisk practices between 2004 and 2012. During this period, roughly 4.4 million stops were recorded, and 83% involved African American or Hispanic individuals, although these groups comprised just over half of the city's total population. The stops were heavily concentrated among young men, ages 14 to 24, the vast majority of whom were innocent, with 88% of stops resulting in neither an arrest nor a summons. Officers frequently justified stops using vague indicators such as furtive movements or suspicious bulges, which often turned out to be harmless items like wallets or cell phones. Evidence showed that police targeted minorities based on a directive to stop the, quote, right people at the, quote, right time and place, a coded reference to stop African Americans and Hispanic youths. Individuals in these communities were more likely to be frisked and subjected to force, and repeated stops fostered fear, mistrust, and psychological harm. Despite the frequency of stops, the practice had minimal impact on actual crime rates, and weapons were rarely recovered. Reforms have reduced the overall number of stop and frisks in New York City, but racial disparities persist, and other cities, such as Philadelphia, Washington, D.C., Baltimore, and Chicago, have faced similar issues with suspicionless or discriminatory stops. Studies indicate that while stop and frisk is a constitutional tool when narrowly applied, misuse through overreach, racial profiling, or pressure to meet quotas can violate civil rights, harm community trust, and have lasting negative effects on the populations targeted. In conclusion, in Terry v. Ohio, the court ruled that a police officer may, in appropriate circumstances, seize an individual to investigate possible criminal behavior based on reasonable suspicion that a crime has occurred, is about to occur, or is actively underway. Officers and the courts may use the totality of the circumstances approach to determine if a number of factors, taken together, qualify as reasonable suspicion to justify a Terry stop. Tips may be used to establish reasonable suspicion, even if they would be insufficient for probable cause findings. Terry frisks must be reasonable in their nature and scope. They analyze movement, length of detention, and the level of intrusiveness of the frisk. And although Terry frisks and stops sound like they are reasonable if applied in a reasonable manner, typically they aren't, and the research shows that they have historically been used in a disproportionate manner against members of the African American and Hispanic communities. I'll see you in Chapter 5.